You may have seen the video I posted last week of police harassing private citizens on their own front porch here in West Virginia. This sort of behavior happens all the time. Cops show up to a private residence, they knock on the door. What are your rights in that situation? What rights do the police have to do what they're doing? Let's make some things clear. Stick with me for just a few minutes and I'll give you the law that you need to know in case you end up with the police at your door. In other words, this is what the police don't want you to know. For instance, in the McDowell County video I just posted, the officer can be heard multiple times in the body cam footage claiming that he had reasonable suspicion to justify his behavior based on the fact that he found what he believed to be 4 marijuana plants near the home. Based on that, the officer demanded the name and birth date of the property owner who was standing on the porch. Can police officers, assuming they have reasonable suspicion to believe that some crime was committed and that the property owner on the front porch may have committed it, can they demand identification under penalty of arrest for obstruction for noncompliance? That's what ended up happening, of course, as you'll see if you watch the footage of what happened to my client Jason Tart. The too long didn't watch answer for this video is no, they can't do that. If police officers are on your private property, that changes things. Cops are trained on the requirement for reasonable suspicion. To develop some reasonable suspicion they can articulate, even if total BS, and then that entitles them, therefore, to forcibly demand identification from whomever they deem a suspect. That's generally how things work in public places, but not on private property, especially a home. Let's look at this scenario of police on your front porch and make sure that we're all on the same page about what the law is and about what the law is not for both police and the occupants of private property. According to the 1980 Supreme Court opinion in Payton versus New York, in order to legally arrest someone in a home rather than in a public place, absent consent or exigent circumstances, police officers must have a warrant. According to the 1984 Supreme Court opinion in Oliver versus United States, the heightened Fourth Amendment protections of the home extend beyond just the interior of the home into what's called the curtilage of the home, which is the land immediately surrounding and associated with the home. Why? Because, according to the Supreme Court, the curtilage is considered part of the home itself for Fourth Amendment protection purposes. The Fourth Circuit, where this porch video occurred, just in 2015 issued an opinion holding that a warrantless search of curtilage is presumed by the courts to be unreasonable. That means illegal. In the 2013 Supreme Court opinion of Florida versus Jardines, the court held that a search undoubtedly occurs when the government, with no warrant, obtains information by physically intruding within the curtilage of a house, which in that actual case involved the home's front porch. The court cautioned that a search occurs unless a homeowner has explicitly or implicitly sanctioned the government's physical intrusion into the constitutionally protected area, i.e. the yard or the front porch of the home. Some of these broad Supreme Court holdings have been interpreted in slightly different ways in different federal appellate circuits. The porch video from last week was from West Virginia, of course, which is in the Fourth Circuit. So the Fourth Circuit made clear as early as 2001 that police officers will be denied qualified immunity if they fail to comprehend that they have no right to enter a home's curtilage to make an investigation based on reasonable suspicion. That was Rogers versus Pendleton. They have no right. All they can do is engage in what's called a knock and talk. This is the scenario in the large majority of these front door type encounters with police. Knock and talks. So that's right. In this case, police officers in the Fourth Circuit were cautioned in 2001 that they would be denied qualified immunity for ignorantly believing that with just reasonable suspicion, they had a right to enter and remain in a homeowner's curtilage without the consent of that homeowner. Yet it still seems that it's being taught to police officers out there, and it's being used right now to arrest people. So, knock and talk. Under the knock and talk exception to the warrant requirement, a police officer not armed with a warrant may approach a home and knock precisely because that's no more than any private citizen might do. This means that there is an implicit license to approach the home by the front path, knock promptly, wait briefly to be received, and then, absent an invitation to linger longer, leave. An officer may also bypass the front door or another entry point usually used by visitors when circumstances reasonably indicate that the officer might find the homeowner elsewhere on the property. This is from case law. Critically, however, the right to knock and talk does not entail a right to conduct a general investigation of the home's curtilage. The obvious difference between a police officer and, say, a young girl selling Girl Scout cookies at your front door is that many, if not most, homeowners have no idea whether or not they have a right to refuse to answer the door or to ask the person to leave. And the police like it this way. They don't inform people of these rights, and the courts have ruled that they have no legal obligation to do so. So you have to inform yourself and spread the word. That Girl Scout cookie or Girl Scout uniform, police officer uniform, doesn't matter. You don't have to answer the door. You don't have to ask them. You can ask them to leave. So police officers and anyone else really, they just have an implied license to come onto your property and knock on your door. So this implied license can be revoked. Homeowners can prevent ordinary citizens and police officers alike from conducting a knock and talk at their front door. And they do that by revoking this so-called implied license to be there. However, again, few citizens know that this theory even exists. Generally, the courts require that a homeowner do engage in some clear demonstration or expression of their orders. For instance, asking somebody to leave or refusing to answer questions. Where there's a gray area, the courts will interpret. So what about no trespassing signs? So this is a topic of dispute, and this can vary by federal circuit. The 10th Circuit had a particularly bad opinion on this case in the Carlos case, which ended up resulting in one law professor creating what he called lawn signs, which were very specific and would provide notice to the police that their implied license to perform a knock and talk at that address is hereby revoked. So no trespassing signs can be ambiguous. One could certainly be more specific and avoid this gray area with some custom signs. Of course, another option is verbally telling the police that they're not welcome. Ask them to leave. That's understandably hard for a lot of people to do. And you know what? Police know this, and they use it against you. Back to the McDowell County porch case. This officer thought he was smart by saying he had reasonable suspicion, and now you have to provide identification or else get arrested for obstruction. But his own footage dooms his defense. He's clearly well inside private property. The homeowners have clearly expressed that they were afraid of him, asking for his name, which he refused. He arrested their landlord by physically seizing him on the front porch, well within the home's curtilage, without any probable cause and a warrant. The video disproves any later claim of exigent circumstances. More than that, and I haven't shown this footage yet, but he radios his superiors on the drive to jail, telling them repeatedly what he had done. There's obviously either a policy of civil rights violations in this department or systematic ignorance, or both. As always, thanks for watching. You'll find more information in the link below to my blog at thecivilrightslawyer.com. If you have a video you want me to review, please send it my way. Don't forget to subscribe for updates and hit the bell notification so you don't miss future updates or future videos. Please like, share, and comment about this video. It helps the channel. It helps the mission of exposure, education, and accountability. If you want to support the channel, please consider clicking the join button, becoming a channel member or sponsor. Remember, freedom is scary. Deal with it. See you next time.
When the police go fishing, they're going to use whatever bait they can to get you to start talking. And lying straight to your face is one of their favorite tricks. And it's legal. Lie number 1, I can't help you if you don't talk to me. That's absolutely not true. Here's the reality. The more you talk, the more there is a chance they're going to interpret whatever you say or manipulate what you say to use against you. The more you talk, the more they will hurt you. Lie number 2, come on down to the police station. I just want to talk to you. I want to hear your side of the story. Look, in reality, it's never going to work that way. This is a professional interrogator you're dealing with. Detectives are trained to make you feel comfortable. Come on down to the station But once you get into the station, they're never going to let you just tell your side of the story. They're going to begin to pelt you with questions, yes or no answers required. And after a while, you'll begin to realize you're actually being asked questions they already want certain answers to. Remember, you are dealing with an interrogation, not a chance to tell your side of the story. The only time you get a chance to tell your side of the story is in the courtroom. Line number 3, this conversation is off the record. Can I tell you right now, there is no such thing as off the record when you're dealing with a police officer. In reality, when he says off the record, the moment you open your mouth and you start talking, the rules are that everything you say can and will be used against you in court. In fact, the moment you begin to open your mouth and answer these questions, the officer is going to use whatever you say and either interpret it, manipulate it, or just decide they're going to use what you say and tie it together with other information to establish probable cause for your arrest and ultimately attempt to convict you in court. What do you say? Officer, I would like to have this off-the-record conversation with my attorney present. Until then, I invoke my right to remain silent. Line number 4, I will personally speak to the judge and the prosecutor if you cooperate with me. First of all, this is almost never true. Very rarely does the detective actually ever speak to the judge or the prosecutor about your cooperation, and most of the time, the judge doesn't really care. The reality of it is, I only usually see detectives doing this if they're placed under cross-examination during a jury trial where they admit that they actually said these things. Otherwise, the judge is primarily concerned whether or not you are guilty of the crime or whether or not there's enough evidence to establish that guilt. Same thing with jurors. At the end of the day, you very rarely see any brownie points being given to someone for cooperating, but you'll be punished through and through if you open your mouth. Line number 5, someone else has already confessed to the crime and they told us what you did. You better start talking. So think about this. So someone else confessed to the crime and then they said something about you? Does that mean you're off the hook? Does that mean you're now supposed to start talking to the police and they're not going to care what you say? They're lying to you. Don't fall for this one. Absolutely tell them you're going to remain silent. Line number 6, we already know what happened, and if you don't tell us what happened, it's going to get worse for you. Maybe they do, or maybe they don't really know what happened. But you deciding to open your mouth is not going to help you one bit. Let's think about this for a second. If they already know what happened, they would have already arrested you. Why even speak to you about it? If they don't know what happened, anything you say is not going to talk your way out of this situation, because if the officer already believes you committed this crime, they are going to choose to hear what you say to fit the puzzle pieces that make them believe they have evidence to arrest you and convict you. Everything you say can be manipulated and twisted to fit the narrative of the police officer, and that can result potentially in your conviction. Line number 7, just take this breath test and I can determine you're sober and I'll let you go home. Let me tell you this, I've seen enough DWI arrests to realize if a police officer is going to offer you a breath test, he wants to use it as a means to determine your guilt, not your innocence. The moment you blow into that breath test, even if you might happen to be under the legal limit, he's going to have you give this evidence along with your field sobriety test so that he can get you off the street and you're spending the night in jail. What if trying to be your friend doesn't work? Then what'll happen is the police will start trying to scare you. Line number 8. We found your fingerprints at the scene of the crime. Now, think this through for a second. If the police come to you, particularly soon after the event that supposedly took place, if they come after you and they say, hey, listen, we found your fingerprints at the scene of the crime, you have to ask yourself this question. If they found my fingerprints, why aren't they just arresting me right now? That is a good indicator they're lying to you. And by the way, if they come to you, particularly soon after the crime, and they're claiming they already have your fingerprints, it's not like they immediately know which fingerprints will match, and they have to have a copy of your prints. Almost always, when someone tells me they have a fingerprint match, I can tell you the police are likely lying. Line number 9. It's probably better for you to go ahead and talk because we already have an eyewitness putting you at the scene of the crime. Many times there's no eyewitness at all, and the cops are allowed to lie about this. I hear cops say this all the time too about a recording. Hey man, listen, we've pulled the cameras over here across the street. We already looked at it and we already know it's you. And it's especially the innocent people that can be at risk here because they might freak out and they'll start to panic. Sometimes it's not what you say, it's what you don't say. So if an officer has eyewitness testimony that you did something, they should already arrest you. And if they haven't already arrested you, there's a very good chance there is no eyewitness or video footage at all. Line number 10. We can get a search warrant in just a few minutes. It's better for us if you just let us in. When the officer says something like this to you, the number one thing you should say is, "Officer, I do not consent to a search of my vehicle or of my property." Why? Because maybe they can or maybe they can't get a search warrant within a few minutes. But think about this for a minute. If they could have gotten a search warrant, why didn't they show up to your place with a search warrant to begin with? Otherwise, there's very little chance that they actually have enough evidence to establish a search warrant, and they're merely on a fishing expedition looking to see if you will be naive enough to allow them to come in to search. The moment you let them in the door without a search warrant, you're giving up the opportunity to suppress evidence that was illegally obtained through the efforts that they created with their search warrant. Lie number 11. Hey man, your friend already ratted you out. I see cops do this all the time. They'll separate the two parties on a traffic stop. They'll get the driver off to the side. They'll get the passenger off to the side. They'll start talking to them. Then they'll walk over one to the other and they'll say, "Hey man, just had a conversation with your friend over here. He told me the drugs in the car were yours. I really don't want to arrest you, but I'm just going to tell you right now, he already ratted you out. And if you don't tell me what really went down here, I'm going to have to take you in." Please understand, police can lie about exactly this issue. If the police already had enough evidence from someone else putting the finger at you, they could just arrest you. It's important to say, "Officer, I exercise my right to remain silent, and I'm asking to have my attorney present for any further questioning." Lie number 12, you just failed a polygraph. First of all, let me give you some advice on this. Never take a polygraph examination with law enforcement. Please understand, polygraphs cannot be admitted and used against you in court. But I've seen officers take polygraph examinations and claim they failed the polygraph, and then they'll say, "Look, man, we really know what happened now. You're lying to us," trying to pressure someone to admit to any of the facts that they can use as a basis for probable cause for arrest. If they tell you you failed, there's a good chance it's a lie. So if the cops can legally lie to you all the time, how do you defend yourself? Don't talk to the police. And if you are going to talk to the police, definitely lawyer up. And if you find yourself in the Dallas area, give our office a call. We're there to help protect you from the lies of the police. But in the meantime, check out this next video to learn 5 ways you don't get outsmarted by the police. See you there.
A Redditor asked, "Is there any law in the US that says I am legally required to answer my door? As an attorney, I can safely say, it depends." Let's see what this Redditor did, what they should have done, and if they got any decent advice from other Redditors in the comments. Is there any law in the US that says I am legally required to answer my door? Was rudely awoken by the police who were looking for the previous owner who has not lived here in at least 5 years. I informed the officers of this through the window as I was basically naked and told them that person did not live here anymore and showed them my ID. I was told that it was illegal to not open the door to police under any circumstance, and that if I did not open the door, they would arrest me for obstruction of justice. So I kindly told them to F off and get a warrant if they wanted to get inside my house. Should I be expecting them to come kick in my door or something? Alright, let's see what Reddit has to say about this situation. Our first answer is you are not legally required to answer your door. Either they have probable cause that falls under an exception that allows them to kick in your door right then, or they need a warrant. There is no in between. Telling them the previous owner no longer lived there and showing your ID through the window was fine. I'm going to agree in part and disagree in part with this answer. First of all, it's correct. In the United States of America, your home is your castle. The Fourth Amendment protects your home. Even if you're a guest there, you have certain rights and expectation of privacy. You don't have to open the door for the police. This officer claiming that you're going to be guilty somehow of obstruction of justice if you don't answer the door when the police demand it, he's just bluffing. Obstruction of justice would require some kind of action normally in order to be found guilty. Now, every state probably has some different understanding, different statutes and case law about what obstruction of justice really is. But in Virginia, for example, fleeing the police is not obstruction of justice. Standing idly by while they bang on your door and one into your home is not going to be obstruction of justice. But not opening the door for the police in the middle of the night is not obstruction of justice by any means under any law that I'm familiar with. This person, though, goes a little too far. KP goes a little too far, saying to tell them the previous owner was no longer lived there, showing your ID. You don't need to do that. You really don't need to give any of that information to the police. Maybe, just maybe, they're lying to you about why they're there. Maybe they're saying they're looking for John Smith and really they're looking for you. I'm not sure that I would show my ID if the police were looking for a certain person. If they said, "Hey, we're looking for John Smith and I'm Andrew Flushy," I might say, "He's not here," and maybe do that. but I don't think I would give my ID at all. Well, some people may say, well, what if they're investigating a crime against your neighbor and they want to see if you have information and can help and be a witness? Well, the police will leave a card. They would leave a card probably with a name and phone number, and you can call them back. Charles ML3 says, not probable cause, exigent circumstances. For instance, if they hear someone smashing out a window to get out or someone screaming for help, they can come in without a warrant. He's exactly correct. The standard is exigent circumstances. So basically, probable cause is required for a warrant to issue. The Constitution itself, the Fourth Amendment, says, no warrant shall issue except upon probable cause. To get around the warrant requirement, there are certain circumstances where the police could come in without a warrant. Let's say they're chasing an armed bank robber who just robbed a bank. He's running down the street with a load of cash and a machine gun, and the police see him running in your front door. The police can certainly come running in your front door after the armed bank robber that they're in hot pursuit of. That would be an example of exigent circumstances. Or in this Redditor's post where he mentioned something about somebody screaming or somebody trying to smash through a window on the back, but if they're just looking for someone who they think may be there, that's not exigent circumstances. That's exactly what search warrants and arrest warrants are for. Reward if lost says, no, you don't have to open the door. And they're allowed to lie too. They need one of these things to get in: your consent, a warrant, probable cause, and exigent circumstances. If they really want to get in your house, they'll need to explain to a judge why they think they should be legally allowed to do it. Then they can kick your door down. That, in part, hits the nail on the head. Basically, you don't have to open your door, right? That's where consent comes in. If the police knock on your door and say, police, we have a warrant, you don't have to open your door. And I would argue that not opening your door, just standing by, not interfering, but not opening, that would not be obstruction in Virginia, I don't believe. However, the police would be entitled to force their way in, and they may damage your door. So if you want to protect your property, the better solution, if they actually say they have a warrant, might be to open your door if they announce they have a warrant. All right, so we have a good interchange here. Movie guy Mike asks, how can you confirm they actually have a warrant? I wouldn't trust opening the door to look at it. Reward if lost replies and says, that's tricky. If they say they have a warrant and they hold up some official looking papers, I'd open the door. I would stand in the doorway to prevent them coming in, and I'd ask to read the warrant. If they really have a warrant, they don't have to wait. I'm just preventing the cost damage of my door being broken down. They can also tell me to get the F out of the way and read the warrant while they do what they're authorized to do. This is an interesting interchange, and Virginia law actually has a really good solution for this. Virginia law says that before the police actually execute a search warrant on your home, they actually have to give a copy of the warrant to the person in charge of the residence to be searched. And so this sort of fixes the problem of how do we know if they really have a warrant. Virginia law has fixed this sort of issue a couple years ago when they amended the search warrant process. A lot of officers don't know this. And the statute actually is very clear in Virginia now, and it says if they don't give a copy to the owner of the residence or the person to be searched, anything found throughout the execution of that search warrant is inadmissible in trial now. And so basically it's a really fatal error if they don't give you a copy of the warrant, and that solves the problem. Depending on your state, they may not be required to give you a copy, but at least if you ask to see it, that hopefully helps document that they in fact do have a warrant. All right, Olympic Llama has a good comment here. Olympic Llama says, open the door, step on the porch, and shut the door behind you. Bonus if you can lock it. If they have a warrant, you let them in. If not, they will have a much harder time getting probable cause. I recommend this for your car as well. They ask you to step out, get out, and lock your doors. The problem with stepping out, if they're actually after you, trying to arrest you, and you step through your threshold, now they can arrest you without an arrest warrant. It's maybe not the best advice in every circumstance to step out of the house to talk to the police. If you stay inside your home, on the inside part of the threshold, you're inside the door, then the police cannot reach in and grab you unless they have an arrest warrant for you. You're in your home. But if the police come knocking on your door and you open the door and you step out to talk to them and close the door behind you, while that does prevent them from seeing into the door and maybe using some kind of plain sight argument about what they see through the door, if they're really there to try to arrest you for something, you've just walked right into their hands and now they can arrest you. But essentially, stepping out may not be the right advice. In fact, I would not recommend stepping out unless you know that they're coming in anyway and you got something right there in the front room that you don't want them to see. But hopefully, if you're up to no good, hopefully you wouldn't have it right there in the front room where somebody coming to the front door could see it. All right, Vormex says they can also get probable cause after you answer the door.
A prenup can outline a clear plan for handling business matters in case of divorce, ensuring business continuity and minimizing disruption. Your business affects more than just you. Employees, investors, and partners all have a stake in its success. A prenup helps protect their interests, demonstrating your commitment to the company's stability and its stakeholders.
Interesting. If I was getting married today, I would absolutely get a prenup. 1,000%. I don't have a prenup in my current marriage.
Oh, wow.
But I would get one. Where I'm at today, I would definitely get a prenup just because of the way the system is built today.
Yeah.
And the way culture has changed and the way the courts are today as opposed to where they were 20 or 30 years ago.
So what about community property states? What's the point of prenups in a community property state? It's a really good question, especially since community property states like California, Arizona, and Texas have laws that already dictate how assets are divided during divorce. But here's the thing, prenups can actually override those laws. With a prenup, you and your soon-to-be wife or husband can customize how assets and debts are divided, regardless of state laws. That can be especially useful if you want to protect specific assets or if you have unequal earning capacities, for example. Plus, prenups can also address other important matters like spousal support and inheritance rights. So even in a community property state, a prenup can provide clarity and protection for both parties involved. And like I've said before, at the end of the day, that can also translate into a happier and more successful marriage.
In order to prove a prenuptial agreement is invalid, you have to prove that one or both parties did not sign it, that the agreement was so unconscionable when it was executed, so harmful, so prejudicial. But you have to prove that the other side, or you, the person who is fighting against the prenup, were not given a full and fair and reasonable disclosure of the other person's assets and debts and income. You have to also prove you did not voluntarily waive in writing any of the disclosure of the financial income, debt, assets, or obligations, that you did not have an adequate knowledge of the property or the financial obligations of the other party.
A farmer and his brand new bride are riding home in a wagon pulled by a team of horses when the older horse stumbles. The farmer says, "That's once." A little further along, the horse stumbles again. The farmer says, "That's twice." When the old horse stumbles again, the farmer quietly reaches under his seat, pulls out a shotgun, and shoots the horse. His brand new bride yells, "That was an awful thing to do." The farmer says, "That's once."
Get a large custom 2-topping pizza for $5.99 when you order online at Little Caesars.
Pizza, pizza.
Get a large custom 2-topping pizza for $5.99 when you order online at Little Caesars.
Pizza, pizza.